Welcome to the latest episode of Call to the Bar, International Law Over Drink. And indeed, welcome to the first episode of Season 2 of Call to the Bar. I'm your host, Dr. Ntina Tzouvala of the University of New South Wales. Now, for Season 2 of Call to the Bar, we have decided to introduce a new type of episode. Imagine something along the lines of what everyone gets wrong about ... insert famous international law case. We will put on our most pedantic, contrarian, or simply detailed-oriented hats on, and we will argue against unhelpful or perhaps just annoying misconceptions. And there is perhaps no bigger straw man to take down than the Lotus Case and its infamous Lotus principle or Lotus formula. To discuss the Lotus Case with me today, we have Professor Douglas Guilfoyle of the University of New South Wales, Canberra, who's of course a regular team member of Call to the Bar, and he has perhaps the biggest axe to grind about Lotus. Hold on your textbook misconceptions. It's going to be a wild ride. Of course, before we begin, I want to remind everyone that in these informal conversations, we are always speaking off the cuff and without the benefit of footnotes. And nothing we are saying should be taken to have been thoroughly peer-reviewed. Of course, before now we go down to the case law, I will open with our traditional first question. Douglas, what's your drink?
Well, Dina, thank you so much for hosting this first episode of Season 2. It's great to be back.
I know.
Slightly less great is the sort of scorching 37-degree temperatures that's 37 degrees centigrade that are presently rocking Canberra. So I'm shivering under the air conditioning in my home office with an ice-cold San Pellegrino limonata. And you, Dina, what are you sipping in Sydney?
Yes, so it's equally hot here. So I'm currently a beverage goblin. So I have on my desk a coffee, a coconut water, and some tap water. So I'm trying to keep hydrated, but also caffeinated.
Tricky balance to keep.
Right. Okay, on to the main event now. Decided by the Permanent Court of International Justice, that is the ICJ's predecessor, in 1927, the Lotus Case famously concerned the collision between a French and a Turkish vessel that resulted in the deaths of 8 Turkish sailors. The collision happened on the high seas, just near the Greek island of Lesbos. Following the events, both vessels returned to Istanbul, where both captains were put to trial for manslaughter. This is where things started getting complicated because the French consul protested against the prosecution and conviction of the French captain, even though actually, just to put this on the record, the sentence that he received was a very mild one, right? We're talking about 80 days imprisonment for 8 deaths. Right, that's less than 3 months, guys. Now on its face, we would think this, or through my modern lens, right, I would think this as a law of the sea question, right? Which state has jurisdiction in the event of a collision at the sea? But that's not exactly how the case was argued, or perhaps more so how the case is remembered. So what happened? There was this dispute between France and Turkey, which they eventually agreed to submit the dispute to the Permanent Court of International Justice. And they asked the following question, and I'm going to read the question because the formulation matters, right, Doug? Has Turkey, contrary to Article 15 of the Convention of Lausanne of July 24th, 1923, respecting conditions of residence and business in jurisdiction, acted in conflict with the principles of international law? And if so, what principles? As everyone will know, the PCIJ ruled in favor of Turkey. In course of doing so, it also produced one of the most famous, or maybe I should say infamous, dicta in the history of modern public international law. I'm talking, of course, about the infamous Lotus principle or formula. In paragraph 44 of the judgment, the court said the following: international law governs relationships between independent states. The rules of law binding upon states, therefore, emanate from their own free will, as expressed in conventions or by usages generally accepted as expressing principles of law, and established in order to regulate the relationships between these coexisting independent communities, or with a view to the achievement of common aims. It's great to see that the writing has not improved. Restrictions upon the independence of states cannot therefore be presumed. Now, Douglas, I know that you have thoughts and that you have feelings about this passage and about the idea in particular that it encapsulated a whole era of thinking about international law, or that it provided, let alone that it still does, a useful way of thinking about the relationship between international legal obligation, sovereignty and state consent, and jurisdiction in this case. To get to these objections, though, I think we need to talk first about the historical context of the case. And to do so, I want to take us back to the question that the parties actually submitted, right? Because it mentions quite centrally this 1923 Treaty of Lausanne. Can you tell us, I was wondering, a little bit about this Article 15 as well as Article 16 of the treaty? And more broadly, could you explain to us why the question of jurisdiction over foreign, and I would say in particular over French nationals, was such a sensitive issue for Turkey in the late 1920s, so sensitive that they were willing to exercise their jurisdiction, even though in reality, I would say this exercise was quite symbolic, right? Like
Right. I mean,
8 days in prison, it looks like you want to put them on trial to make a point.
right. Right. And I think that's correct. Dina, one of the things you've taken us straight to there is the stakes for the parties, at least symbolically or politically, seem much higher than the question. Right? You know, why would you go to the Permanent Court of International Justice about a case where your national has been tried in a foreign court and got off so lightly? As you've said, 8 negligent deaths, 80 days in prison. Most of us would call that a win. Write a cable back to Capital saying, you know, we've done a great job, and you tied it off there. So there's something more at stake. Now, first off, there's going to be a lot of proper nouns in foreign languages in this episode. So for every mispronunciation today, I'm just going to plead Australian, right? That's my fundamental defense. I've also made the joke in previous episodes that any legal answer to any legal question that begins, we have to go back to the Ottoman Empire, is prima facie madness and needs to be dismissed. I am going to break that principle because we do indeed need to go back to the Ottoman Empire to explain what's going on here.
Broken clock twice a day. Here is the
Yeah. No, every rule has an exception, I guess, as we'll come to. But so the capitulatory agreements of the Ottoman Empire lasted, roughly speaking, from 1535 to 1923. And some of the longest running capitulatory agreements, and I'll get to what that means, were between France and the Ottoman Empire, or I believe between some of the German states before the unification of Germany and the Ottoman Empire. So these effectively involved a network of treaties that made particular concessions from the Ottoman Empire, or as we would now think of it, Turkey, and various European powers. Now, briefly, what these treaties did was grant foreign nationals not only freedom of movement within the Ottoman Empire and freedom to practice their own religion, which were significant matters that you might expect to be regulated by treaty, but they also gave foreigners a series of economic and legal privileges, notably including the establishment of so-called consular courts, so courts attached essentially to embassies, with jurisdiction over disputes between foreigners. So this had the effect of turning the Ottoman Empire into something of a free trade area for Europe. When we think about those sort of minimally regulated zones in developing countries under some modern agreements, this is essentially what we're thinking of. Now, unsurprisingly, this state of affairs, lasting as it did for the better part of 4 centuries, was not particularly popular with local ruling elites. Now, at the end of the First World War, which basically saw the dissolution of the Ottoman Empire, the empire concluded a very harsh, fairly one-sided peace treaty with the Allied powers, the 1920 Treaty of, first mispronunciation coming up, the Treaty of Sèvres. So this resulted in the partition and occupation of Turkey, as well as the reimposition of the capitulatory regime. Now, that was never accepted by the emerging nationalist government of Mustafa Kemal, better known to Australians as Ataturk, the brilliant general in the First World War. And after the Turkish War of Independence against the occupying powers, it was replaced with the 1923 Treaty of Lausanne, as we've mentioned. So the main objective of the Turkish negotiators at the Treaty of Lausanne was the abolition of the capitulatory regime. Indeed, its elimination had been considered by Ataturk as a non-negotiable condition for the cessation of hostilities. So in essence, what the new Turkish Republic wanted at this point in the treaty was a vindication of its right to be regarded as an equal sovereign under international law. So that was the key thing at stake for this new ethno-nationalist Turkish government, was how we build a modern nation state out of an empire. And how we get that sovereignty as kind of an exclusionary concept recognized against the Europeans. So Turkey sought during these negotiations an express acknowledgement in the treaty of the competence of Turkish courts to prosecute crimes committed by foreigners beyond Turkish territory. So Dina, this goes exactly to your point about this looks like a bit of a symbolic prosecution to say we're entitled to do this.
We can do this.
Right, right. So this proposal, though, this Turkish proposal was rejected, and instead, and you'd asked me to come to Articles 15 and 16, Article 15 provided that all questions of jurisdiction shall, as between Turkey and the other contracting powers, be decided in accordance with the principles of international law. Now, you said before the drafting of ICJ judgments hasn't noticeably improved in a century. Equally, the drafting of treaties hasn't noticeably improved, right? When two sides can't agree something, you include an open-ended clause that goes, essentially goes, this is plainly a controversial issue, so we're going to state that it will be resolved in the future in accordance with international law. Right.
As we know, the best definition of a treaty is a disagreement put down in writing. That's one of my favorite lines.
Absolutely. Attributable probably to a number of sources, but I always attribute it to Philip Allott. Interestingly, writing on the Law of the Sea, I think, at the time. But then Article 16 goes to these questions of personal status and family law. Not necessarily criminal jurisdiction, and it just says that Turkish courts could exercise jurisdiction subject to international law. So again, the issue is punted to international law. Now, as we'll come to, France relied heavily on this drafting history in the course of the case, which is another technique in disputes, right? If the treaty on its face doesn't say something helpful to you, plead that, aha, if you were at the negotiations, you would understand that what was really intended was this. Okay, so yes, I think that covers your question.
More than does. Yes, fantastic. So there is this big historical background, right? And I think in a sense, we have established that what Turkey thinks was at stake is its standing as not a declining empire anymore, but an emerging and having emerged nation state, right? And it's worth also keeping in mind that basically the 1923 Treaty of Lausanne comes at the very end of a war, right? So Greece, my own nation state, acted basically as a sort of like intermediary of this occupation. They ran a military campaign that reached very deep into Turkey, and of course at the end ended up losing the war. A terrible campaign of ethnic cleansing happened, and the Treaty of Lausanne comes to ratify that. in a sense, right? So as you implied, for Turkish nationalists, what is at stake is having a legal case that ratifies both the treaty, well, not in the technical sense ratifies, but also their military victory, right? To
Right.
win the war and then lose it in court would be quite the feat, right? So this is a broader political context. But it is also worth flagging that the court decided the case on relatively narrow grounds, right? And I know that this is one of the things that annoys you about the Lotus formula, that eventually it wasn't influential in how the case was actually decided. Can you walk us through, Douglas, the reasoning of the court?
Okay. Now, stepping through the reasoning is tricky. So I'm going to sort of highlight a big issue, come to the narrow question, and then try and use those two poles to kind of frame what the court did. So the big picture point here is that under the presidency of Max Huber at this point in the 1920s, you've got an ICJ in the way Ole Spearman and other scholars of the PCIJ describe it is it's sort of at a turning point. And the turning point is a sort of jurisprudential one around the meaning of sovereignty. Now, that may sound a bit kind of off the wall, it's international law, it's been around for a while, surely we understand what sovereignty means. But there's this sort of question of the attitude of mind you take towards international law, right? Are you a national lawyer who's just sort of doing a job of dispute resolution on the international plane, or is international law some distinct discipline and profession? And it's that sense of international law having its own disciplinary orientation, its own professional integrity that's kind of bubbling to the surface here. So you have these two visions of sovereignty, right? If you're a national lawyer, you start from the proposition that your state is sovereign in a plenary sense. All power resides in the state. The way it's put in British constitutional law is Parliament can make or unmake any law whatever. So if a state is fundamentally a thing of plenary competence, then you're going to assume it has a very wide margin of appreciation in terms of the kind of legal acts it can take. Alternatively, is the fundamental starting point that the existence of other equal sovereigns must limit your sovereignty, that you can only be sovereign to the extent that all other states are sovereign. I think this has a corollary in sort of Republican theories of law that, you can only enjoy rights to the extent that others also enjoy the same rights. And obviously, France doesn't, in the way this case is pled, believe that Turkey enjoys the same rights as it. Some states are more equal than others. That is, in a sense, the core of the dispute. Now, what the narrow point that was actually decided was that the PCIJ did not decide that ships are floating pieces of territory. That's really important. They did, however, essentially say these are jurisdictional objects that for some purposes, when a ship is on the high seas, a ship can be assimilated to the territory of the flag state. Now, classic international law 101 lecture on jurisdiction scenario, if a gun is fired across a border between France and Belgium, who has jurisdiction over any resulting murder if someone is killed on the Belgian side of the border? And the usual answer is both. Right, the state of active nationality where the crime was commenced, France can exercise jurisdiction, and the state of nationality the territorial state where the consequences were felt, can also claim jurisdiction on the basis of the effects principle. The effects were felt in our jurisdiction. We can add another layer of complexity by making, the two people involved in the case foreign nationals as well. And then we could say that the states of nationality of the offender and victim could also have a claim to jurisdiction as well as the territorial states. So, unsurprisingly, on the basis of these sorts of analogies, the PCIJ says it is only natural that each state should be able to exercise jurisdiction and do so in respect of the incident as a whole. It is therefore a case of concurrent jurisdiction. So this is pretty straightforward. All we're saying is, hey guys, concurrent jurisdiction exists. There are a lot of different principles you can apply to criminal law jurisdiction. There's not much to see here.
And they had already gone to Istanbul, so there was no problem with the enforcement jurisdiction of Turkey in this instance, right?
Right.
Like they had voluntarily gone back to Istanbul.
Right. So, but then we get to the passage you've already quoted. But I think it helps rereading it in light of this sort of view about, which conception do we take to sovereignty, that of the national lawyer or that of the international lawyer? So international law governs relations between independent states. The rule of law binding upon states therefore emanates from their own free will, as expressed in conventions or by usages generally accepted as expressing principles of law. So there we've got the voluntarist theory, the consent-based theory of international law, that's fine. Then we've got two further sort of sentences. And established in order to regulate the relations between these coexisting independent communities or with a view to the achievement of common aims, then restriction upon the independence of states cannot therefore be presumed. Now, those two things don't run together, right? Everyone focuses on that last bit, which sounds like the national theory of sovereignty. Yep. Sovereignty is plenary, therefore you can't presume restrictions. But the sentence before it points the other way. International law is about regulating the coexistence of independent communities with a view to achieving their common aims, which is one of interdependence and multiple sovereigns having to live together. So given that those two things point in different ways, what is the function of the classic sentence? Restrictions upon the independence of states cannot therefore be presumed. So again, the literature goes to this. Everyone in the textbooks subsequently tends to treat this as a starting presumption. Your baseline is we don't presume restrictions. Alternatively, though, it could be read as a rule for dealing with non-liquets. That is, to unpack the Latin, what do you do when the law runs out, right? If there is no applicable rule, what are the presumptions that you use to fill a gap or to answer a novel and unregulated question? But then the further question is, does this affect the court's reasoning at all? So the court goes on after that paragraph to say, now the first and foremost restriction imposed by international law upon a state is that, failing the existence of a permissive rule to the contrary, it may not exercise its power in any form in the territory of another state. In this sense, jurisdiction, here they mean enforcement jurisdiction, is certainly territorial. It cannot be exercised by a state outside its territory except by virtue of a permissive rule derived from international custom or from a convention. However, they then go on to say, on what appears to be about a point about prescriptive jurisdiction, it does not, however, follow that international law prohibits a state from exercising jurisdiction in its own territory in respect of any case which relates to acts which have taken place abroad and in which it cannot rely on some permissive rule of international law. Now that's a bit jumbled because now we'd say the permissive rule is the effects doctrine, at which France already had in its criminal code, right? So France is there saying it is invalid for Turkey to invoke jurisdiction over events occurring beyond its territory. And one of the first submissions made before the PCIJ by the Turkish advocate is to say, well, France does this. This is blatantly hypocritical. Then, and this is the bit where I go, actually, at this point, we have to set aside everything the court has said. It says, nevertheless, it has to be seen whether the foregoing considerations really apply as regards criminal jurisdiction or whether this jurisdiction is governed by a different principle. At which point I'm like, hold the phone, right? Everything that we always quote about the Lotus case leads up to something that basically says, but on the other hand, right?
Okay.
And they then note that though it's true that in all systems of law, criminal law is principally territorial, it is equally true that all or nearly all these systems of law extend to offences committed outside the territory of the state which adopts them and do so in ways which vary from state to state. So essentially they go, Actually, you look at extraterritorial criminal jurisdiction, it's a mess. We haven't yet distilled it into an acceptable range of forms of extraterritorial criminal jurisdiction. We don't think the law is crystallized, but yeah, we reckon ships on the high seas, you can assimilate them to territory, apply the effects principle, and we're away to the races. So what's extraordinary about this case is you have all of this digression, and then they go, but we're not sure that applies to criminal law, and we're going to resolve this case this way.
Yes. So
So
your point is that none of this huge edifice that they are erecting actually grounds this specific ruling, right? That at the end is decided on pretty like unimpressive grounds. Like
right. So
yeah,
the thing is, everything that we normally think of as being the Lotus case is
yeah,
in sort of, law 101 terms, obiter dicta.
yeah,
It's just stuff that is said in the course of the court thinking aloud, and the actual ratio decidendi, the actual point on which the case is decided, is just to say, yeah, on the high seas, you can treat ships as if they were territory, and in the event of a collision, both states have concurrent jurisdiction, and that's it.
yes. And I'm wondering also, in light of everything we've been saying so far, if this sort of very high-minded comments about the nature of independent states and the source of legal obligation can also be read directly or indirectly as a way of specifically affirming the legal equality of Turkey, right? Because they're talking about a world of sovereign equals who are interacted based
Right.
on their consent, while France implicitly or explicitly does not think that this is what's going on here,
Right.
right?
Right.
Or they might think that this is what's going on with its dealing with Britain or with Germany or
Right.
whatever, but not necessarily with its dealings with Turkey. And I'm not necessarily saying that this is what the court meant, but I'm wondering if this is a more historically grounded reading than
Yeah.
saying that this is necessarily about the source of legal obligation.
So I think that's probably right in the sense that one of the things we don't get in just reading judgments, let alone just reading textbooks summarizing judgments, is an impression of how much the court in its judgment is answering the submissions put by the parties and speaking to the parties first. So the French argument was essentially references to international law and general principles of jurisdiction in the Treaty of Lausanne have to be read in light of the negotiating history,
Yes.
where Turkey put up an express provision that it would have jurisdiction over foreign nationals in respect of events occurring abroad, and that wasn't included. So, in a sense, the French argument is implicitly Turkey has the jurisdiction the Allies gave it
In
in the
Lausanne.
peace
Yeah.
treaties, which, as we may come back to in another episode, has some eerie parallels to the way that certain Israeli scholars argue about the jurisdiction available to the Palestinian Authority or the
And
State of
therefore
Palestine under the Oslo Accords, right?
yeah.
It has only the jurisdiction we have conferred or acknowledged. So I think that is definitely a part of it. And just an interesting note about the advocates is that the French position was put by Jules Bastevant, who later went on to become a member of the PCIJ and its president. He was this very august person who I think had also participated in like the negotiation of the Treaty of Versailles for the French delegation. And you have this fiery, Swiss-educated, younger Turkish lawyer pushing the nationalist case,
Mm.
Mohammed Esat. But this was also the time when Turkey was introducing, again, in terms of modernizing by adopting and adapting Western conventions, had introduced a surnames law, right? And he added as one of his names, after winning the case against Bastevant, Bozkurt, the name of the Turkish vessel that had
Yes.
been
Yeah.
sunk,
right? Yes, that's
So
an amazing piece of trivia. So I want to come back a little bit to the particular case, right? And the what you mentioned in passing earlier, which is the PCIJ in a very nonchalant way, accepted the implication of concurrent jurisdiction, right? That there will be events taking place where more than one states have prescriptive jurisdiction, right? And of course, let's go to the sea in particular. This is very good news, if you the family of the deceased, right? Or if you are a vulnerable person seeking remedies for a harm suffered on the high seas, right? Because it means you can go to Turkish courts or you can go to French courts, right? Or if you are a third nationality, even perhaps to a third court. However, I'm wondering if you are the captain, of a ship, this seems to be raising the possibility of facing proceedings starting in more than one state, right? About the same set of events. And I was wondering if anyone else but at the time had these thoughts. Instead of gesticulating about the nature of the international legal order, I'm more interested in how actually actors on the ground reacted to
right.
Lotus.
So seafarers unions hated it, is the short answer. Like they got very, very exercised about the idea of double jeopardy or the possibility of one of their members being hounded through the courts of multiple states. And again, there are sort of modern echoes here of arguments against universal jurisdiction, right? That it could become impossible to conduct politics if politicians are exposed to prosecution in any state, anywhere someone alleges they've committed an international wrong. Similarly, seafarers were like, well, who's going to be the captain of a ship if, in the event of an unfortunate collision, they could be prosecuted anywhere? So there's a push that masters should only be prosecuted either by the flag state of the vessel they're in command of, or perhaps the state that's issued their license as a master. So that's still not that still has some potential for double jeopardy if those are different states, but it limits the field. So you have this big push, takes a number of decades, but it first results in the snappily named International Convention for the Unification of Certain Rules Relating to Penal Jurisdiction in Matters of Collisions and Other Incidents of Navigation, 1952. And then the core of that rule is taken first into the 1956 High Seas Convention, and then is now found in Article 97 of the UN Convention on the Law of the Sea, which, again, in terms of trivia, Lotus is notable for being possibly the only ICJ or PCIJ case that has expressed a rule of international law that has gone on to subsequently be specifically overruled by multilateral treaty.
Right. So it's interesting, right? Because instead of worrying about where does consent and legal obligation come from, it seems that actors at the time cared much more about the substance, right? It was a controversial case, but much more about its substanting ruling rather than these abstract principles. And that's actually something I wanted to ask you, right? Looking back into this case, and especially reading your own work about it, what I find so striking is the disjuncture between what actors made of it at the time and how it came to be digested in the discipline, right? It seems to be there is three different cases here, right? There is the case of Turkish nationalists who see this case as a case about asserting the equal sovereignty of their young republic. You can see it as a case from the perspective of seafarers, in which they see it as potentially a floodgate sort of concern about being prosecuted in multiple jurisdictions and no one wants to be our captain. And then you have international lawyers, a profession that, as you say, gets stabilized as a profession a little bit later, perhaps, who think this is about a secret third thing, right? It's about the very nature of the international legal order. And I was wondering if you have a take on how and why international lawyers came to be so detached from the concerns and the legal struggles that actually took place in 1927 and let's say
Right.
before 1927.
Well, I guess the first sort of thing to say is, look, you're right. I mean, this was a big case symbolically for Turkey, and potentially a big case for seafarers' unions. But in the broader suite of world history, this is not an important case, right? Like there are plenty of episodes in which foreign nationals die and they do not result in international
Right.
litigation. And in a sense, this concerns now what is one article of the more than 300 articles of the law of the sea. So, why has it become such a big thing that it's in every textbook and often underpins so much in legal argument, particularly when it's never expressly been followed, as far as I can see, in subsequent ICJ cases, right? So its actual impact on subsequent case law
Right.
is also next to nil.
It's not as if it's being cited and
No.
picked up all the time.
So I've got a couple of theories. One is just the observation that actually very small incidents sometimes do become very symbolically important in the life of the law. So the classic law of negligence in English tort law obviously stems from Donoghue and Stevenson, and
Nails.
one what would now be considered a fairly minor trade practices case, right, where someone is drinking insanitary ginger beer and discovers a snail in the bottle. So maybe there's a rough analogy there, except that the modern law of negligence is actually significant and has gone on to be applied by other courts. So one of the things I think is that the judgment is, when you read it, so schizophrenic about what the job of international law is. And it
Right.
does go to that bit about what is the function of international law?
Yeah.
What does sovereignty mean? How do we conceptualize ourselves as international lawyers? And so for that reason, I think pretty much everyone reading it has something to be outraged about, right? The methodology does not lend
Whether you're a
itself.
sovereigntist or a
Yeah,
international community person, it says both things you like and things that you hate.
right. And also, I think in kind of the culture of textbook writing and the way we explain law by telling kind of, and I suppose this goes to the sort of point Tamsin would make, we do law by telling stories to some extent, right? And one of the ways we often start a textbook chapter or a class is by explaining why something is wrong. And once that becomes a sort of default habit, you have these sort of whipping boys like, oh, the court got the law so wrong on this occasion. And it helps explain why things are now different and better. So you get this objectionable principle plucked out of the Lotus case and then disparaged forever in textbooks. But on the flip side, it's also quite useful, right? So was it Nietzsche who said anyone who invokes humanity is cheating? No,
Oh, Schmidt.
it was Carl Schmitt, of course. Well, similarly, I tend to think that anyone who invokes Lotus is cheating, right? So you'll often now come across international law articles going, well, there's no rule of international law that says this is permitted, but there's no rule of international law that says it's prohibited. Therefore, we apply the Lotus and we can do it until a prohibitive rule emerges. And I've
Yeah.
seen this in articles about kind of the early days of thoughts about cyber espionage and cyber conflict, and also some aspects of, say, submarine operations. People have said, well, the Lotus case tells us we can do this until we violate some other rule. We don't have to have a title that legitimates our actions.
Right, right.
So it remains both a convenient whipping boy when you're writing about international law, and also a convenient get out of jail free card when you're writing up a controversial opinion.
That actually makes a lot of sense to me. Like especially the second point that you made, that you can introduce practices that feel illegal, but say, well, in the absence of an explicit prohibitive rule, we can do it, and ignore the bit of paragraph 44 in which it says the coexistence of multiple independent states. Otherwise, if you just had one independent state, law
Yep.
would not make sense. The whole point is that it
Oh,
regulates.
yeah,
It
yeah, yeah.
actually
If you
would be nonsense.
Right, if you live on a planet with only one territorial entity and only one state,
Yes.
then yeah, go nuts. It makes
Yeah.
perfect sense.
So I said before very briefly that I have really benefited from your own writings on the Lotus case. But I wanted, before we start wrapping up, I wanted to ask you if you have anything to recommend to those listeners who want to learn a little bit more about the case.
Sure. Well, and thank you for plugging my own writing on this, which is principally a book chapter in the volume Landmark Cases in Public International Law, which I'll link to. But I'd also really like to plug, and again, I'm going to mispronounce his name terribly. You may do better on this, Dina. Umut Ozsu's article, Deterritorializing and Reterritorializing Lotus, Sovereignty and Systematicity as Dialectical Nation Building in Early Republican Turkey. I got a lot about the Turkish perspective from his writing, and it was his writing that inspired me to kind of go back to both the pleadings and the biographies of the advocates, which I found really illuminating about what the stakes actually were. In terms of the afterlife of the Lotus case and how little jurisprudential influence it's had afterwards, there's a great article by Hugh Handyside, The Lotus Principle in ICJ Jurisprudence, Was the Ship Ever Afloat? And coming to a sort of similar conclusion to me, that essentially what we take as the Lotus Principle, that states have an absolute freedom to act unless expressly prohibited, is based on an incomplete reading of the Lotus judgment. So coming to that same conclusion from a different direction, Anne Hertogen's Letting Lotus Bloom in the European Journal of International Law, I also think is excellent.
Fantastic. And my recommendation would be for those of you interested in particular in the capitulations history, there is a book by Turan Kayaglu called Legal Imperialism, Sovereignty and Extraterritoriality in Japan, the Ottoman Empire, and China, that does a really, really good job in capturing both the history of the capitulations, but also what Douglas was talking about, which is the centrality of capitulations in emergent nationalist consciousness in these places, how capitulations and this restriction of jurisdiction came to really be a red flag for emergent nationalisms in the late 19th and early 20th centuries. Okay, I think we should slowly wrap up, but I want to ask a couple more questions. We usually ask an international law question about escape routes or skills acquired outside academia. But today I have a question that is in the middle of not international law, which is, Douglas, why do you care so much about the Lotus case? Like, that is one of the first things I knew about you. What is the backstory here? How did you come to spend so much time thinking about it? And how has it influenced your own work, perhaps?
Yeah, no, thank you. So I do think this still sort of fits broadly within our sort of secondary theme for the podcast, which is career history, right? So, how did this become my bête noire? I think something that often drives research is being really irritated by just kind of going, this is wrong and I hate it, but I can't articulate why, or this is driving me up the wall. Everyone seems to see something here, but the longer I stare at it, the less I see. So all of this started for me when I was writing my PhD and someone asked me, oh, what are you writing your PhD on? I can't even remember who the villain of this story is. And I said, oh, stopping and searching ships on the high seas. And they went, oh, so surely you'll need to write a chapter on the Lotus case. And I was like, oh, oh, maybe I do. Oh dear. And so I went away and tried to write it. And the more I wrote about it as a PhD student, the less I understood it. And then, in a sheer act of desperation, just to get someone to tell me to stop, I gave 20 awful, awful pages on the Lotus case to my PhD supervisor, who, as I've probably mentioned before, was James Crawford. Right. So, imagine,
Mm.
imagine like putting up, to your supervisor, let alone one of kind of the greats of his age, something you strongly suspect is not that good. And he just passed it back to me and said quite kindly, but in retrospect, a little cuttingly, something along the lines of, I too have had the humiliating experience of writing 20 or 30 pages before realizing it's completely wrong and I need to start again.
Kindly is one way to describe
Look,
it.
it was the harshest thing he ever said, and he prefaced it with this sort of idea that, it's something everyone encounters. What I then did was reconstruct the PhD so I did not have to discuss the Lotus case. The time-honored coward's maneuver. If you can't, if you're not smart enough to deal with it, define it out of the scope. But then I wound up in my first job teaching both sort of general public international law at an undergraduate level and international criminal law at a master's level, and jurisdiction is a big part of both of them. And so I just kept having to read the Lotus case. And once I started reading it as a case
Your
about,
nemesis. Yeah.
and once I started reading it as a case about jurisdiction, and I was reading it not as a piece of theory, but just as an ordinary case, I went, wait a minute. All of this stuff everyone gets excited about is obiter dicta. It doesn't go anywhere.
Yeah.
There's just this, on the other hand moment, and then they go off on a different tangent and go, yeah, actually, it turns out all sorts of principles are used to justify extraterritorial criminal jurisdiction. It's not, the law isn't settled yet. And yeah, France claims extraterritorial criminal jurisdiction over foreigners. This isn't particularly unusual. We can just, come up with this high seas analogy. And it was only as I started doing that, I was like, oh my goodness, I don't think this case is what people think it's about. And then I eventually jumped at the opportunity to write on it, and inspired by others, particularly Umut Osu, I went back to the pleadings, and I went back to the historical context, and I went back to biography.
Yes.
And then I just saw the case in a completely different light. And at about that time, I was also, as I've mentioned before, involved for a number of years as an external legal advisor to Mauritius in their Law of the Sea case against the UK. And suddenly I rediscovered something I'd sort of known from an early career in litigation in Australia, that how the case is pled and its wider context informs how the judgment comes out.
Yes.
And now a lot more of my scholarship is about kind of reintroducing that process to an understanding of what international courts do, and asking more, as we've spoken in previous episodes of the podcast, about what's in it for the applicants.
Yes. What are they trying to get out of it?
Yep.
Yeah. And I think that's, sorry.
No, I was done.
No, I was just saying, I think we have had this discussion in private, but I think the fact that you can go to the ICJ website and there is hundreds and thousands of pages
Right.
of pleadings and of submissions, and it's such a natural and easily accessible archive.
Right.
I had the same experience with the Southwest Africa cases, advisory opinions, the whole shebang. It's such a ready curated archive, and you learn so much about cases. And I think international lawyers, at least academic international lawyers, I should say, don't lean on them enough.
No, not at all.
You can understand so much.
And this was a big part of the pitch
yes.
of my present project to the Australian Research Council, was to say cases, international law cases, assemble their own archive in a way that historians could only dream of. And thousands of pages is just sitting there on the ICJ or PCIJ website, and we don't look at it, largely because we don't have the time. Right?
Absolutely. So yeah, like I think one thing to take away from this, maybe broader, even for those who don't care about Lotus, is just go and download.
Right. Or in the present age, even if you don't have the time to watch all of the pleadings in
Yeah,
a case like
yeah,
the ICJ's advisory opinion on climate change, have a look at some. If you look at social media, people will review particularly impressive speeches, but also think, what are the small island states saying about this? Who have they hired to make those pleadings? Watch even 15 minutes of this stuff and you get a different perspective on what's going on.
agreed. Agreed entirely. Okay, I think that was a great way of dispelling some myths, and it also came with some, let's say, methodological research advice. So I think we can
And a
draw
lot of fast speaking and hand gestures from me. I mean, the fast speaking will
exactly.
come out in the podcast, but not the emphatic hand gestures that Dina suffered through all episode.
But also, what will not come out of the podcast is what you're wearing. And I want to ask you because it's very different to what Douglas is usually wearing. Douglas, would you mind telling our audience what is your current outfit?
So, Dina, as we discussed earlier, it's really very hot in Canberra. So I'm working from home with the air conditioning on. But in the manner of air conditioning, right, you can never quite get it right. You're always too cold or too hot. So I'm sitting at home working in a casual shirt, which is covered in little suns with faces. And then over that, I'm wearing a really light dressing gown made of recycled sari material with
Beautiful.
yeah, yeah. No, the net effect is, as my wife sometimes put it, eccentric middle-aged wizard in charge of a wizarding school.
I can reassure people that that's not inaccurate. Okay, thank you so much, Douglas. Thanks everyone for listening, and we will see you soon.
Bye bye, everyone.